Right. For friends, colleagues joining us from across Eastern Africa, it's a very wonderful afternoon as you join our session this beautiful Thursday afternoon, 16th of April. I would like to welcome you all to this very wonderful session. As you settle in and get comfortable, please share the link with a friend and tell them that our session is on, and we're streaming live on both YouTube and our Zoom platform. For those who are watching on YouTube, good afternoon. Thank you for subscribing to our YouTube channel at East Africa Law Society. Now, friends, it's a pleasure really to welcome you for our webinar this afternoon titled Climate Justice in Action, Lessons from East Africa's Landmark Litigation and Crossroads. So like we all know, East Africa and across the region, climate change has become increasingly shaped out of our policy spaces. But also this has stretched into our courtrooms where we have constitutional rights, environmental law, and community voices redefining accountability and justice. And today's session will bring together leading practitioners, thinkers, and experts who have really made a niche on this field to reflect on this evolving jurisprudence and the practical lessons that emerge from landmark cases in the region. We are indeed particularly privileged to host a very distinguished panel who will guide us through the key dimensions from this conversation. We'll be discussing an array of subtopics from constitutional claims and procedure challenges to community impact, intersectionality, and regional policy responses. And now, without further ado, it's my honor to introduce our esteemed moderator and coordinator for this session. Our moderator is a legal counsel specializing in energy, infrastructure, and sustainability with close to a decade of experience in advising across renewable energy and construction sectors in Africa and in the Asia Pacific region. She holds advanced degrees in environmental law and economics from legal global institutions and actively contributes to regional legal development through the East Africa Law Society Energy, Environmental and Construction Committees. She brings a rare blend of expertise, policy insight, and commitment to sustainable development. Now, ladies and gentlemen, join your hands and welcome with me Miss Flavia Nasambu to guide us through today's session. Flavia, it's very lovely to see you. Thank you for making time for us and in particular coordinating this very wonderful session. We'll now hand it over to you to take it on. You have us until 4 p.m. So, uh, yeah, it's your time to take us through and we can't wait to learn. Thank you.
Thank you so much, Gabriel. You say it's my time. I hope I get to shine through this time. Thank you so much, Gabriel, East African Law Society, for having this session. Going through the material, coming from Kenya, working in the energy space, I realized how important having such a session is, not only to the practitioners, but also to the NGOs involved in climate litigation and also the people impacted by climate litigation. So thank you so much for this session. My name is Nasambu Flavia. I will not speak as to my experience. I think Gabriel has touched on it thoroughly. I'll just like to say thank you everyone who's joined this session. Thank you to the panelists. Thank you to the NGOs that are part of this session for the works you've been putting on environmental litigation. And also thank you to the public who've taken time to join this session. I hope the next 2 hours will not be a waste of your time. You will get out of here with something that is close to your career or close to your life or just new knowledge that is relevant. So again, thank you so much and stay with us through the 2 hours. Sorry if I repeat what Gabriel has said. In the next 2 hours, we are going to touch on climate justice. And I will start on it from this point. Couple of years back, as a region, our focus when a project was being developed, it was the monetary value of the project to the community and the nation at large. We would look at what that project will translate in terms of employment, what that project will translate in terms of, sorry, royalties, and what that project will translate in terms of revenue. Even then, we minded about the environment, but based on the discussions today, you will see that recently we've grown from just looking at the monetary benefit, and we are also significantly focusing on how that project is going to impact the resources around the project, how that project is going to impact on the people around the project and the people who've been displaced, for lack of a better word, by the project. And whatever we're going to look at today is not just limited to project. Based on the constitutional provisions, we are going to see also how we can look at our governments and say, we have entrusted you with these resources. How are you handling it? Climate change is a reality other than to Donald Trump, but it's a reality to majority of the people. What are the do's and the don'ts that you're supposed to do, and what are you doing and not doing about it? And also, as Gabriel has indicated, we are also going to look at procedural challenges in environmental and climate justice. When you're instituting a case in court, what will the court expect you to do? And in case you do not do it, then what will make you be barred from exercising your rights? And then we'll continue to look at how projects intersects with the community and how, as a joint community, we can litigate in regards to climate justice. And finally, we are going to look at how the decisions of the court can be translated into policies in the different regions. So again, with us, we have a distinguished panel, very, very well experienced ladies, a lady and gentlemen, and they're going to take us through this. So I will start introducing them, and then we can proceed from that point. Lynn, because you're the lady and not just because you're a lady, I would like for you to start by introducing yourself. Tell us a little bit about yourself and what you've done in your career in regards to climate justice, just briefly, and then we will proceed with the other speakers as well. Lynn, welcome.
Thank you. Thank you, Flavia. I'm out in the field, so I want to conserve my network until I really need to have my camera on. But I could put it for 5 seconds. Hi to everyone. So my name is Lynn, and I have been in the extractive sector work for 15 years now. I started out with the petroleum sector, supporting work around putting the required laws in place, working together with communities, working with international oil companies in Uganda in 2010. I transitioned to the mining sector in about 2016, 2017. And since then, I've been working very specifically around, again, mining sector laws and regulations, and then also interacting with communities and mining companies with a specific focus on the artisanal small-scale mining sector, because across the continent, ASM contributes about 85 to 90% of the continent's mineral production. So I've participated in some legal, some litigation surrounding extractives, but mostly I think that's the reason why Gabriel asked me to speak on the section, because I've spent a bit of time with communities, local governments, women, gender empowerment in the mining sector. Thank you.
Thank you so much. Thank you so much, Lynn, for joining us. And we are happy to gain insight into your experience. I agree with you. I think certain sections of the community are impacted disproportionately, and we'd like to hear more into that. Our next panelist is Mr. Kiza Iron. Mr. Kiza Iron is a human rights lawyer and a poet. Tell you what, I think all lawyers are creatives except me. So we hope to spare 5 minutes at the end of our session and get to hear a poem from Mr. Kiza. Please introduce yourself and speak to what you've been doing on climate litigation briefly, Mr. Kiza.
Thank you very much. I think you have really done the introduction, but suffice to say that I've been in human rights since 2013, human rights and public interest litigation. I took a very active role in environmental litigation since 2020, sparked by the destruction of Bogoma Forest, and I've doubled down since then. We have worked on some matters ECOP and being consulted by colleagues also on cases to do with holding corporations accountable for their activities against project affected persons in the Albertine area. And so we have tried to help project affected persons, we have defended trees, we have defended forests, and so on and so forth in litigation, both nationally and at the East African Court of Justice. But beyond the litigation and concomitant with it is I do advocacy. I just don't end at filing pleadings in court. I also do some advocacy under the auspices of the Environment Shield, especially, but in collaborations with many other civil society organizations. So I am as active in court as I am on Twitter about the environment. Thank you very much. We are not hearing you, Flavia. Unmute yourself.
I'm sorry, I had muted. Thank you so much. And we are happy you're sparing your time to come speak to us what you speak freely on Twitter and more that you've been doing in courts. I would like to introduce Mr. Rugemeleza Shala. I'm sorry if I'm mispronouncing your name. He's been doing great work. He's the founder of Lawyers Environmental Action Team, which has really done so much in regards to climate litigation. Mr. Nshala, please introduce yourself and briefly just speak as to what you've been touching on, the highlights.
Flavia, Dr. Anshala will be joining a little later.
All right.
See. Thank you.
Understood. All right. And then with us, we have Mr. Leon Mulama. Mr. Leon Mulama, we are happy to have you. He's the head of legal Agnes. I think he can share in detail what that means. Equally, he's been engaging on various litigation on matters that significantly have impacted some of the projects in the region. So, Mr. Mlama, please introduce yourself and just highlight some of the key things that you've worked on.
Yeah, thank you. Thank you very much, Flavia, and thank you very much to the East African Law Society on organizing this very impactful convening. Allow me to start with a quote. There's a Swahili proverb, or more or less quote, that one stick can smoke, but it will not burn. And I really resonate with this when it comes to climate change, because climate change takes a whole of society approach and a whole of government approach. So back to your question, my name is Leon Mulama. I currently serve as the head of legal and local representative at Agnes. This beautiful lady called Agnes is the African Group of Negotiators Expert Support, and it's a continental non-for-profit think tank that provides technical backstopping to African governments, to the African Group of Negotiators, and of course parliaments, and of course experts, which right now we're also including lawyers and judges. And so some of the work we've been doing around supporting lawyers and judges is we've been developing capacity building programs, developing tools to help some of our lawyers when they undertake their responsibilities to undertake their work more effectively. So apologies, you may hear a bit of background, but currently we are in our pre-SB meeting ahead of the joint sessions in Bonn. But it's a pleasure to be here, and I'm looking forward to learning and contributing some of our knowledge.
Asante sana Mlama, asante sana. We are happy that you've taken time to be with us today, and we are hoping to learn from you. I'm sure you charge the others that you teach. We are grateful that you're going to do it to us for free. So asante sana. As stated earlier, we are going to look at various areas, and the first area that we are going to look at is the basis of legal claims in regards to climate litigation. And the person who is going to take us through that is Mr. Kiza Ezron. I will start with this question to you, Mr. Kiza. How has environmental rights provisions in the constitutions in East Africa used to frame climate and environmental litigation?
Okay, thank you very much for that question. It's important to clarify that all the three major East African countries have positive, constitutionally guaranteed environmental rights. The best or the gold standard is Kenya, but Uganda also has a very good provisions in the constitution, Article 39, and also Article 20 that adumbrates the obligations of states to respect, promote, and protect rights. So combined together is a very strong constitutional base for environmental rights. The Environment Statute of Uganda, the National Environment Act Cap 181 or 2019, is very clear on that, on the environmental rights. So we have a strong statutory provision in Uganda, almost as good as Kenyan. Tanzania, not as much, but they are catered for in the national objectives and they are part of the constitution. Yeah, so the rights to environment, because they are constitutional, because they are statutorily guaranteed, provide a strong normative framework with which to confront environmental degradation in the East African region, in each of the domestic states. Less clear is the situation in Ichgari, in Sudan, and DRC. To me, I need to do more research about that. In Kenya and Uganda, we have been vigorous at the national level in enforcing the environmental rights. So pollution can be framed as a violation of the right to a clean and healthy environment. Deforestation can be and is framed as the same violation or a threat to environment. In 2024, we got a good judgment stopping the cutting of urban trees in Jinja. So that's an example. And there are some other cases. Much earlier in Uganda, we had declaratory judgments about the smoking being violative of the right to clean and healthy environment. Around that same constitutional framework, you can anchor procedural guarantees or procedural rights. Just beyond the norms, also procedure, for example, rights to public participation are very, very important. Rights access to information, they reinforce the obvious clean and healthy environment. From there, you build into international frameworks on sustainable development, on SDGs. In Uganda, green growth, circular economy, precautionary principle, all those wonderful principles of the right to a clean and healthy environment are part of the statute and that's also the same story in Kenya, and there are comparable efforts in the rest of the East African countries. So there is a strong legal basis, foundational, legal and constitutional basis for enforcing human rights. The challenge is with the courts and the politics. The political will is is almost zero. And instead of aligning with the populations in both countries, normally is in collusion with international capital. So the question is people and planet versus capital and political power. How do you reconcile those dynamics? So for us to successfully realize these rights, we need states siding with the people. Because we have seen that whenever states side with multinational corporations, then these rights become illusory because the context in which they are enforced, namely the judiciaries, can be influenced, can be manipulated either using money through corruption or threats or appointing mechanisms, promotion mechanism, basically selection and recruitment of judges and other bodies. In Uganda, there is a promise of a special division of environment, but in Kenya, it's not a promise. There is actually land and environment tribunal. It is doing very well. I think one of the judges did very well in the interviews for promotion. So at that normative framework, we are very strong. Maybe you can repeat the question so that I see what I forgot, so that I put it in.
No, I think you've touched significantly on what we are looking at because we wanted to understand the legal basis, and you've highlighted constitutions in different regions as areas that people can use to claim different rights.
Maybe before you go, so the other aspect of legal basis we are talking about ESC is the East African Treaty.
Yes.
The East African Treaty in Article 5, in Article 101 or 111 up to 114 provides a legal framework for enforcing sustainable development, for dealing with transboundary environmental degradation, the obligations of states to conduct the environmental impact assessments, especially for projects that they may have transboundary environmental effects. So it gives us a framework to deal with climate change issues, both mitigation and adaptation. And basically, whatever we can do at the local level, we also have an alternative legal regime at an East African level, subject to the time limitation of 60 days. And it is so strictly enforced that it's really, it makes no sense of our rights. Thank you.
Sorry. And I think one of the panelists is going to bring it close home in regards to the East African Treaty and barriers in regards to implementation of part of the treaty, especially the 60-day period that you've spoken about. I would also like you to touch on one doctrine that I think it's very, very important. People from Kenya, people from Nairobi, and I think this would come close. And this relates to public trust and the rights that citizens can have to claim against the government in regards to their actions to resources and their reaction to climate change. I think that is very important because I would like to tie it to the close happenings in Nairobi. So if you could speak to that, and then we can tie it to close happenings in Nairobi before we can move on to the next panelist.
That's very important. How did I forget that? So in the constitution of all the states in East Africa, states as trustees, or they take care of natural resources, namely forests, wetlands, lakes, minerals. They hold them in trust for the citizens of the country, but not just the present generation, for today and tomorrow. So states have an obligation to ensure that they manage these resources, natural resources, sustainably. They ensure that they are used wisely and that the benefit from them today does not compromise the ability of future generation. So the public trust doctrine is part of our constitutional framework, and it also encapsulates the intergenerational justice doctrine, and combined, they work very closely with the right to clean and healthy environment. They are mutually reinforcing and also provide that the polluter pays. Hence the issue of the polluter pays principle, and also the precautionary principle that if you are dealing with interrogating development projects, anything that may be uncertain as far as science is concerned should not be a reason, an excuse for not protecting the resource. If you must err on the side of caution, whether you are a state agency, or even in court. The precautionary principle is very important and works and feeds into the public trust doctrine, the intergenerational justice doctrine, and other concomitant doctrines, sustainable development, and so on and so forth. So that's very important. Thank you for the reminder.
And we are going to, I think other panelists will speak about other cases that will tie some of these doctrines that we are speaking about, especially public trust, and it will maybe bring it close home. I'm trying to pick some of the issues that relate to the people in Nairobi, just to summarize everything that you've said. So for the legal claim, we have basis in the Constitution and the East African Treaty. And also we have the public trust doctrine. Under the public trust doctrine, basically people in Nairobi, let's assume in regards to climate action, I mean, what is it called? Climate change. Let's assume if the flooding in Nairobi was caused by climate change, if the government could have prevented this or done something such that the damage could not have happened to the people, then you have some basis based on public trust to claim against the government. Remember, I said, let's assume. And then in regards maybe to the government handling of resources like Karura and such other areas, if they're cutting resources and they're supposed to preserve it for the future, then we have a basis for claim in regards to that. Basically, that is what Dr. Kiza has taken us through. And before we go to the next panelist, I would like to tell the audience that you can submit your questions after the presentations from the panelists. We are going to look through your questions and then they will get to answer them. So please just type into the comments anytime, and then we will look through them much later after presentation from the panelists.
And as they type those questions, it's important to recall to mind that in July last year, the highest court, the International Court of Justice, gave an advisory opinion on the obligations of states regarding climate change. And to your Karua forest scenario, governments have an obligation to protect carbon sinks from destruction. They have a duty to preserve them because carbon sinks for mitigation purposes, but also forest as adaptive mechanism to help states in their obligations to adapt to climate change. And these obligations are not just provided for in the climate treaty, whether it's Paris Agreement, United Nations Framework Convention on Climate Change, the Kyoto Protocol, and so on and so forth, but also as a matter of customary international law, because climate law itself derives from environmental law, and most of the norms we have already talked about, the public trust doctrine, polluter pays principle, the intergeneration, the precautionary principle, all are part now of customary international law. And if flooding is predictable, the state has a legal obligation to protect it. Even the right to a clean and healthy environment is now a matter of customary international law. So I just thought that we need to remember that we have a new ball in our arsenal of the climate advisory opinion of the ICJ. Thank you very much.
Thank you so much, Dr. Kiza. That is very, very much.
We just sound like one. Thank you. Thank you for the prophet.
I'm speaking to your future. Thank you so much. Thank you so much. That is very informative. And again, thank you for being part of this panel. We proceed to Dr. Nshala. I hope you're here. Is he here yet, Gabriel?
Not yet. We can proceed.
All right. All right. Then we proceed to Mr. Dickens Kamugisha. And in this third area, we are going to look at project impact cases and community mobilization. Many climate justice cases arise in the context of major development projects, including oil pipelines, geothermal developments, and of course, carbon offset initiative. These cases demonstrate how climate litigation can influence decisions around development projects and environmental governance. So Dickens, to you, I'm going to ask this question. Many of the cases that your organization engages with involve large development projects such as oil and gas, as we've mentioned, and energy projects. From your experience, how has environmental or climate litigation affected planning, approval, or implementation of these projects?
Yeah, thank you, Flavia, and all the colleagues who are in this meeting. One of the things that maybe I think I had not introduced myself. I'm called Dickens Kamugisha. I work with Africa Institute for Energy Governance, AFIEGO, here in Uganda. And I've been in this field, the climate litigation, environmental litigation, since 2009. I have never stepped in court. I am a lawyer for communities. That's the work that I do. I only work and advise communities on how they can go to the lawyers who can help them in court and be able to ensure that they get justice when they get problems. So the question that you are raising, I will be asking my colleagues online in this meeting to be, what is environmental litigation? What is climate litigation? What is climate justice? Because all these are things that are very critical for us to understand. Why do we talk about communities? How do we ensure that communities that get or suffer injustice are able to get justice? Where do these communities live? And the other question is actually, what are development projects? Because in most cases, and the reason why at the moment the lawyers are getting problems, for governments and companies, they have their definitions of what are development projects. And the assumption that a development project is actually, no one should talk about a development project. Myself, the time I joined the civil society, I had worked with the government as a state attorney with DPP. I served for 7 months. After 7 months, I felt I think I should go and work with people. And the reason, I had read the case which was filed against the Attorney General in Uganda. It was in respect of one of the central forest reserves in Uganda called the Tamira Forest, where the High Court had ruled that it was illegal for government of Uganda to gazette a forest, a central reserve forest, and change its land use. And unfortunately, even when the court had determined that the project was illegal, that judgment was never enforced. And I think I felt that maybe because it was only 1, 2, 3 NGOs that had filed the case, there were no people that you would say, oh, the people themselves were interested, had knowledge about the case, understood the, the objectives of the case. So from that case, I said, oh, maybe these communities really need to be involved. That at the end of the day, whether you get a good outcome from court, if people are not involved, some of those judgments can be ignored. So the question about how do litigation or climate litigation or environmental litigation affect development projects? We can give examples. I think in 2016, there was a case in Kenya, the Ramu Core case. I think that is also another Rocus Classicus case where if you look at how that case was managed, it was a case where the government of Kenya had given had wanted to do a coal power plant, and the people of Kenya and the organizations in Kenya said that project was not legal, because it was awarded without the participation of the citizens. And after some good years of the engagement, the court agreed with the applicants that that project should stop because there was no public participation. And yet, those communities, those people were going to be impacted by that project. So that is like a project that was a core power project, a huge one of $2 billion US. And some people at first were blaming the ones who had filed the case. How do you file a case to stop a project of $2 billion US? Because they were looking at the jobs, the revenues, huge positive impacts. But they forgot to know that even that supposedly good project, if we were to assess its social, environmental, and economic impacts, possibly you'd find that actually the benefits are not the best, but the negative impacts are the worst. So when we are talking about development projects and how climate litigation affects them, sometimes you can also change the question. How do development projects affect people and their rights? Because at the end of the day, do you focus on just the project, or you also take into account the social, economic, and environmental aspects of that project? So there is no doubt whatsoever that litigation or environmental litigation affects development projects. In Uganda here, we've been engaging in the ECOP case, the East African Crude Oil Pipeline. That is a project that is 1,443 kilometers long, but it is a project that is affecting over 120,000 people. It is a project which must get its reserves from one of our biggest national parks called Murchison Falls National Park. It is a project supposed to get its crude from under the Lake Albert, and it is a project that has displaced thousands of people. For the development people, they look at how many people have been displaced or how many people have lost their crops. But if you look at you assess the impacts of these projects, people who are not directly affected actually also in the long run, they get affected. Today, since the oil activity started in Uganda, especially in 2012, our national debt was around $12 million US. Today, the national debt is over $30 billion US. And if you go to the oil region and you see the projects, the roads, the airports, where they have invested this money, you start asking, if something happens, this debt, it does not matter whether you live in that village where the pipeline is passing or not, you will get affected. You with your children, the education, the health, and all the clean water, all those can be affected. It is also, this ECOP is a project that is passing through lakes, rivers, wetlands, forests. One of the, I think, again, I need to say in terms of the climate litigation, one of the cases that landed myself and 7 of our staff in police cells for 3 days was the Bugoma Forest. It is also one of the central forest reserves in Uganda. That forest, before the oil activity started and the oil companies opened the roads, that project had remained intact for generations. When they opened the roads and many people started coming, looking at land positioning, the land prices increased. Everyone now started saying, we want a portion of this forest because the roads are there, the land has increased in price. So we said, no, this oil that is coming here, which is, they are saying is going to transform this nation, if it is going to lead into destruction of these critical resources, let's find a way to stop some of these projects that are destroying our nature. we filed the case. And the number of phones that we got to leave that case. And when we insisted that that case was legitimate, because there were over 30 communities that live around that village, over 10,000 people petitioned the president. And those are the people that we mobilized and filed the case. Of course, we had representatives who filed the case. But because we are the organizations that we're organizing, you are in police cells, you suffer all that injustices. And along the way, you actually get all the threats you can think about. And we had to withdraw that case. I'm happy that the Errol Chiza filed part of it at the East African Court of Justice. And unfortunately, it is taking long. The forest is getting destroyed. But I think the point I'm trying to make is that development projects are definitely affected by climate litigation, but climate struggles are also affected by these projects. And at the moment, I think what we also need to be looking at is like the civic space within which to mobilize these communities to make sure that they play their role. The space within which even the judges and the magistrates actually sit to determine these cases. Because sometimes the lawyers think that, oh, it is a matter of having evidence. You just go and present it in court, and then you expect the judge and the magistrate to make a ruling. At least my experience is that supporting, empowering communities to file the cases is the most critical part of ensuring that you help people get justice, you defend environmental rights, but we also have to take a step to mind about these judges and magistrates. They also want to live. They also have their families. So if Dickens, working with an organization, gets threatened and reaches a point of withdrawing a case, not because that the case is bad, because the Bugoma Forest in the High Court, it was ruled by a judge and ruled against us. If we looked at that ruling, the judge was blaming us and saying, oh, we filed the case in order to be seen by the public, in order to please our donors, instead of looking at the evidence that we had filed. So when we appealed, and then we got all those threats and decided to withdraw, I said, okay, what about this judge who has received this good evidence and is going to rule in favor of the communities who are saying this project is risky, is dangerous? So how do you ensure that such a judge, such a magistrate is also protected? So that is also in terms of climate litigation and environmental litigation. We need to be very mindful that when the space is becoming very hostile to the lawyers, to the communities, even the judges and the magistrates are also not safe. And they are going to make rulings and judgments in against us, not because actually under normal circumstances they would have ruled against us, but the conditions they are very hostile and they are not willing to suffer the consequences. The other point that I wanted also to make was about how do communities or community participation influence legal strategies? I think all of us, by the time you say, okay, there is an environmental injustice or climate injustice, a community somewhere there has lost its forest, has lost its access to clean water, and this community needs justice. Or a project that has been assessed environmentally, socially, is dangerous and risky, it should be stopped. And you say, okay, we can go to court and stop it. There are a number of things that we have to take into account. And my experience is that there are many, many cases in Uganda here and in Kenya, in Tanzania, because when we are in the ECOP case, for example, which is a project cutting through Uganda and Tanzania, we wanted to file we wanted to be around 8 organizations. And I tell you, all of them were happy with all the evidence that was there, but they could not. 4 of the organizations said this project is risky, we cannot go there. So at the end of the day, you'll find, oh, the legal strategy that you are going to use. Do you want to file as one organization? Do you want to be the one to file you as an organization? Or do you want to go and make sure that the communities that are directly affected appreciate the social, economic, environmental issues, and they are the ones actually filing the case, and they are in big numbers, and you say, okay, even the court would be saying, oh, these are the people, this is how we are affected. So I believe that, even that strategy is a good strategy, but how many lawyers, what capacity do we have to make sure that we are not just going as individuals, but we are mobilizing, especially those people affected. So for like Afiego, we've been working with mobilizing and empowering law students in universities. And I'm happy a number of many young people have formed into organizations, and they are doing a good job today. Majority of the big organizations, because even the people are getting old, not very old, but someone who is 40, you have a family, you have a number of many people, you are saying, oh, if government is very hostile to us who are filing cases, I am not willing and I'm not ready to spend days in prison. So let me start censoring myself. Let me start trying to dodge, trying to make sure that even when you don't leave the organization, you are doing things that are irrelevant. That is an area that I have seen that, along the way, because of the hostile environment, because the climate litigation, the development projects we are talking about, they are in billions of money. And the companies and the government are telling people, oh, you are going to get all the things that you've been missing. On the other side, you have really intervened, you have assessed these environmental and social impact assessments, you see there are no mitigation plans, there are huge risks, and so the government is saying, oh, they are very good things. You are saying these things you are talking about are going to be overshadowed by the risks, by the dangers. And I am telling you that in the process, because these are the people with security, with everything, they harass you, who is telling people that, you people, you need to protect your rights, you need to protect your nature. So it is becoming a very complicated thing of how litigation is impacting development projects, because the development projects are the ones that are looked at by the government and companies as something critical. The impacts of those projects are not taken very vital. Most of the communities that try to speak out, they are actually suffering. So that is an area that I would want to invite people when we start discussing what can we do. Because to be honest, most of us, we know projects are important, but also the project that you see as the best project, if you don't handle it well, if it doesn't take into fundamentals of accountability, fundamentals of people's rights, fundamentals of environmental rights, that project can turn out to be a dangerous project. And the process for us to mobilize people, for the process for us to ensure that we get good decisions from court, it requires much more than filing a case and presenting evidence. And all of us, we need to look at. Aaron talked about the different laws. We know for sure, right now in Uganda, they are coming up with they have a bill called the sovereignty bill, supposed to ensure that actually NGOs don't get money, or you get very little money. Supposed to declare what you are going to do with the money. So at the end of the day, what we are talking about is that the development, the growth of the climate litigation, the growth of environmental litigation, the activeness of the citizens to participate in these affairs that affect them, all those are being curtailed by the government and the companies that don't want to be accountable, to be transparent, that don't want to be questioned. They think, oh, people are just small people, so they should not question. Thank you.
Thank you. Thank you so much. Thank you so much, Mr. Dickens. And I apologize that I had missed out in introducing you before. I'm really, really sorry for that. We appreciate your input on this, especially on the areas that you've highlighted, including the indirect impact of the projects in regards to debts rising, and the cost of the land and projects around that area also rising, but also the danger that the litigants and everyone involved in the litigation process is exposed to as a result of fighting any project. I think when we were starting, we said we are progressing and looking at the impact on the environment and not so much money. But I think you grounding us and telling us that money is still a major factor, and whoever owns the money is the biggest player in the game. I think it's an important thing for us to be aware of. If we do not have Mr. Kiza joining the session, I would call you back much later so that you can speak on standing, because I feel like it's important for, other than legal professionals who've joined the session, I think it's important for the public to be aware how they can litigate through organizations like yours, and how court accepts that. But let's wait for him. In case he does not come in, then I will come back to you in regards to that. All right. On the next page, now we are going to go to our fourth panelist. And in this case, we are going to talk about intersectionality, that is rights, equity, and vulnerability. And basically, it's just to show that the projects and even climate change impacts certain communities, rural communities, women and youth disproportionately. So she will highlight some of the cases like Osman versus NRT and other cases so that she can show how the communities are impacted by this. So Ms. Lynn, would you just speak into the intersectionality of climate justice and the impacts on disproportionate impacts to the communities? Lynn, do we have Lynn?
Hi. Yes, I'm here.
Right.
As I said, I'm out in the field and I'm moving from one point to another. So I'll just speak very quickly and then maybe for 10 minutes so that we can move to a better place. Okay. I'm so pleased I'm coming after Dickens Kamujisha, because I worked with Dickens in 2010. It was actually at Afiego that I entered the civil society space, and I'm proud that was the beginnings of my advocacy work around the extractive sector. So if we can quickly sort of frame the conversation of climate justice, we'll see that when you think about the definition of climate justice, human rights, equity, and accountability come into play. We know generally that East Africa contributes less than 1% of global emissions, but faces severe impacts to livelihoods, whether it's the flooding or severe drought that then touches on food security. Climate change is very real for the peoples in the East African region. As imagine
Lynn, your network is not as stable.
And
can you hear us? Can you hear me?
That Dickens pointed out very clearly is that and we tried to ensure that the network was stable. Hello?
All right, it's better now. It's better now.
It's better. Okay. I don't know where but let me just continue. Yeah, so as Dickens spoke earlier, he talked about communities or peoples who are living close to the places where, say, development projects are happening. They tend to be the ones to to bear the burden of whatever climate effects, climate change effects any project will have on the environment surrounding them. And this is where courts come in, as litigation is an emerging for justice for these peoples. How can courts respond? When we're interrogating intersectionality, it's important, it matters, because impacts are not equal. They're not the same from community to community, country to country, gender, impact experienced depending on community. And this things like growth, incomes, as well as livelihood. One of the sector, as I've said, for the last 10 years, I've been involved in the mining sector. The ASM sector, when you think about vulnerability, intersectionality, you find that there are overlapping vulnerabilities common, especially when women in rural communities are involved in the ASM sector, right? So gender is touched, income status is touched, geography, a rural community versus an urban community, and then the artisanal and small scale mining sector as well. So you see that for this one individual, this one woman, that have vulnerability to climate change impacts is increased just because of where she lives and the livelihood that she participates in. There are also questions or conversations about exposure, sensitivity, and adaptive capacity when we talk about climate vulnerability or climate change impacts vulnerability. I wanted to speak a little bit about the ASM sector because it's the climate change effects are very Uganda gold, the ASM gold.
Sorry, Lynn, to cut you a bit. Sorry. Maybe
Yes.
if you could remove you could just speak without the video, maybe the internet will be a bit more stable comparatively.
Okay, exactly. Okay, let me do that.
Thank you.
All right. Yeah. So I was saying that I thought I could focus on the artisanal small scale gold mining sector, and especially in Uganda, but the sector is not very different across the region. In Uganda, the ASM gold sector is a major livelihood sector, but it's riddled with informality, land conflicts. There are a number of environmental risks that come from the activity, digging of pits and not following up on covering them, use of dangerous chemicals like cyanide and mercury that gets into the air, the water, and the land. But when we talk about the ASM gold sector within the frame of climate justice, you do realize that they have weak bargaining power largely because of the informality and so on. The effects also stretch towards environmental degradation by deforestation, and they are also quite vulnerable to mine flooding and mine collapse. Now, the Uganda's mining sector framework has evolved in the last 15 years, I would say. There is a Mining and Minerals Act that was passed in 2022. And in there is a big formalization agenda. And the understanding is that the government of Uganda is committed to supporting artisanal and small scale miners to formalize their work, to professionalize their work. But the justice question still remains: who is included and who is left out? When you look through the law, even though it's quite progressive, made provision for the artisanal and small scale mining licensing, which did not exist earlier, there's still some challenges that exist. Obviously, with limited formalization, professionalization, a law like this one can risk exclusion, right? Because the requirement for compliance and licensing is steep, and there is an understanding of the government's objective in doing this is trying to bring them up from the very informal and lower level to a more organized and formal level. But we must always ask this question: who is included and who is left out by these laws? I again trying to understand this whole question of climate justice and intersectionality. I would want to look at two cases. The first one is the Center for Food and Adequate Living Rights versus Uganda and Tanzania, the East African Court of Justice, which was challenging the Uganda-Tanzania oil pipeline project and the claims related to human rights violations, environmental harm, lack of community participation, and which is something that Dickens raised very clearly, that when you're trying to pursue climate justice, you need to involve the communities that are directly affected, because then it becomes more meaningful, even as you come before a court and provide evidence and so on. The case raised climate and human rights intersection, but one thing that is clear is that the case was dismissed on procedural grounds, a question of timing and so on. It wasn't a procedural question. It wasn't a substance question. It was more on procedural grounds. And from this case, it's very clear that procedure can block justice, right? Even as much as like Dickens was raising the issue of economic realities, if I can put it like that, yeah. Judges, magistrates, lawyers being compromised because of sort of economic realities. But the laws themselves, good as they are, as Council Kiza raised and very clearly stated, they're really good, they're well set out. But he also raised the issue of political will and kind of a lack of that political will, but then also back to that economic realities conversation. Procedure can block justice if there is no will and sort of autonomy and independence at the courts level. The other case is the Endoroi Welfare Council versus Kenya from ACPR, a 2010 case. This one was bringing out issues of violations of property, culture, development, and a lot of the conversations in this case were around indigenous rights and free, prior, and informed consent. And what I like about this case is how it ties in again with something that Dickens so very well raised. It established that development must benefit communities, otherwise it's not worth pursuing. But you see, again, very good outcomes from courts of justice. But what happens when it comes to implementation? So we can clearly see that the trend, regional litigation trend, is towards looking at climate litigation through a human rights lens. There's more human rights. There's an increase in human rights framing and strategic litigation that is emerging across the region. Climate cases are increasingly being framed around right to life, right to livelihood, as well as right to the environment. Again, as Council Kiza clearly pointed out, it's something that even at the international level is becoming more clearly linked. So what I see as a meaningful justice pathway, and once again, I'll agree with Dickens, start out with a community and then support their organization, increase their legal awareness before then you move to litigation, because without that, there seems like holes can continue to exist, and then it can also be easier for governments to single out individuals and then pressure them towards dropping off the cases or just letting go of the fight. But when you have big community participation, and these communities are organized, they're supported to organize, and they are legally aware to the best of their ability, it can support better outcomes at the litigation level. And then with increased litigation, strategic litigation, and good outcomes from the courts of justice, we can begin to see policy change that is meaningful. Okay. I'll just speak a bit about legal strategies for inclusive climate justice. Again, council keys are constitutional rights that are available across the region. And so constitutional rights litigation, framing your litigation or your cases from the foundation of the Constitution can be helpful in getting better outcomes from the courts of law. Public interest litigation also is a good way to bring climate justice issues to the fore and get good outcomes, as well as, in my opinion, the leaning more into the regional courts, East African Court of Justice, HPR, and the rest. As well, again, we cannot emphasize this more community-led cases, or cases that have communities involved and understanding of the need, and they have legal awareness. So law plus evidence plus community voice means that litigation becomes accessible, and you can hope for better results. So what are some, sort of practical takeaways that one can have, even as I come to a close of this conversation? Climate justice is equal to or commensurate to social justice. This is the truth, because at the end of the day, we are thinking about future generations, how our children are going to be affected, our grandchildren, and so on, even not just stopping at just our level or our lifetime. The other repetitive thing, but very, very important, is that communities must lead and law must be accessible. And then taking into account intersectionality is not optional. That's absolutely important for lawyers before they go before courts of law to do some assessment, seek the support of other professionals, especially the ones that are involved in social development, environmental and social impact assessments, gender impact assessments, people who are trained in this direction or who have some experience in doing this can provide very valuable information and data that can support your case. And once you wrap the law around it, you can be hopeful of better outcomes before judges, because then it touches on human rights, on the right to life, which any judge or magistrate ideally should be able to understand. So I'll stop here so that I can allow for the rest, and also allow us to move to a better network area. Thank you, Flavia.
Thank you so much, Lynn. Thank you so much. And thank you for the work that you're doing for the region, taking time to work with the communities in regards to the development, understanding the risk exposure to you as an individual because of such works, I think whatever you're doing is very commendable. I have a follow-up question, but maybe I will ask on it as you give your closing remarks, because I'm curious to see how community involvement can be proactive. And then also just maybe you can touch on the difference between public participation and community involvement during the litigation phase. But I think you can address that maybe a bit much later as we are nearing, as you're submitting your closing remarks. I will proceed with Mr. Mlama. I hope you're still with us. And for you, we are going to look at, I think many people have discussed about various cases that have gone to court and favorable decisions that we've gotten from the court or not. How can we translate these court decisions to laws and policies that are binding to the people and will get to have the desired change in regards to climate justice? Karibu, Mr. Mlama.
Asante sana, Flavia. I trust you can hear me still.
Yes, we can hear you very well.
Now, allow me first to reiterate what the previous speaker, Council Gitu, alluded to. Climate litigation and environmental litigations are strategic litigations. They are both components of strategic litigation. What does this mean? This means that the goal is broader than a typical litigation where you're seeking remedies or you're seeking maybe equitable remedies in terms of damages or some of those remedies that are available. Strategic litigation targets a broader influence. It targets to influence policy. It targets to influence legislation. It targets to influence how governments undertake their activities. And so before I answer your question, allow me to share a story of Wangari Maathai. In 1989 and 1990, Kenya tried to build a convention center at Uhuru Park. That was during Moi's era. And this had numerous impacts. It was projected to have numerous impacts on the environment. It was projected to contribute to climate change. It was projected to significantly reduce the number of recreational and I would say green spaces in Nairobi. And so Wangari Maathai stood up, she saw this and said, no, we can't allow this to happen. So she wrote letters to ambassadors, she wrote letters to the Attorney General, she wrote letters to members of parliament, she even wrote letters to the then president. All these came to deaf ears. And so she decided, then my next course of action should be to go to the courts. So she went to the courts and detailed her arguments precisely, but the AG only had, the opposing counsel only had one fatal defense. Wangari Maathai does not have locus standi. She does not have the capacity to bring this action before this court. And just like that, all the work that she had been doing, all the work that she intended to do with the litigation was stopped because she did not have locus standi. And so this raises a big concern as to if our courts are restricted by the law, how then can these courts themselves advance climate law? So for those who are interested in this conversation, you can read Wangari Maathai's book, Unbound, and the case itself is Wangari Maathai versus Kenya Times Media. So you can get the broader understanding of this instance. And funny enough, 2 years later, we went to Rio and we got the Rio Declaration. And Principle 10 of the Rio Declaration gives us three main, I would say, three main entry points for public participation. The first one is access to information. The second is access to justice. And the third is meaningful and participatory participation. And so this, I'm just alluding to this story to show how sometimes the law can be inhibitive or restrictive to what we intend to achieve in our environment or climate change ambitions. And so back to your question, Flavia, courts do have a role to play when it comes to contributing to our laws or our policies, but specifically on the interpretation side. We are very cognizant that there is a separation of powers between the executive, the legislature, and the judiciary. So the judiciary has been smart when it comes to interpreting some of these legislations, or they do so in a broader term. They don't use, in law school, I learned about 3 main interpretation rules. The first one is the literal rule, the mischief rule, and the golden rule. And so sometimes courts use this mischief rule and the golden rule to broaden the scope of what is intended. And I can give an example. In 2006, we received a decision that was from, in the case of Peter K. Waweru versus the Republic. The decision, the judgment was rendered in 2006. The background of this case was that the people were trying to build some, they were building a residential commercial buildings, and they had a sewage stroke waste management plan, which would emit into the general surrounding. And so when the government chemists or government scientists, when they were doing their rounds of inspection, they tested the waters around that building, and they found that, it has a lot of waste. And so they brought it before court, and now this was an appeal which Peter was filing. And so the courts were saying this was remember, this was in the previous constitution where we did not have Article 70, where we have the enforcement of environmental rights. So the only right that the state really hung on was the right to life. And so what the court did was interpret it broadly and say the right to life includes the right to a healthy and clean environment. And this elevated environmental rights to the concept where even the laws themselves or the courts themselves are enforcing it. And that is how we ended up getting the subsequent Article 70, Article 42, in our constitution, and Article 70 in our constitution on how to enforce environmental rights. Another example I would give that courts have interpreted or contributed to the generation of climate law policies is on the clarification of ambiguous terms. So sometimes you may find that the initial law was not quite prescriptive, and that's normal for any law that is typically passed by Parliament. It's not intended to have every detail or every scientific interpretation or everything. It's supposed to have quick, short, and actionable provisions. And so sometimes there are some omissions. And an example is our environmental, social, and impact assessments. If you read, let me use the Kenyan example for now. If you read section 57A of our Environment Management and Coordination Act of 1999, and together with section 23D of the Climate Change Act, you'll find that we need to do environmental impact assessments. However, these environmental impact assessments do not include climate impact assessments. Yet we know that some projects, when implemented, do contribute to climate change, do contribute to greenhouse gas emissions. And so in 2023, the Green Belt movement, that was the Wangari Maathai's institution, together with the Wangari Maathai Foundation, submitted a petition before the tribunal, telling them that it was against a company. I'm sorry, I'm blanking on the name, but if I remember, I'll revisit it. And where they said, these guys, yes, they've done an environmental impact assessment. Yes, they've given us a study report, but it does not take into consideration climate change impacts. Yet we know that by implementing this, you're going to have climate change impacts. And the opposing counsel on the other side was saying, but when we read the environmental impact assessment provisions in our laws, we're not required to do a climate impact assessment. It is not there. So the court broadly interpreted it and clarified that yes, environmental, social, and impact assessments should also include climate impact assessments, and that has contributed significantly to how we undertake our environmental impact assessments. If you look at any EIAs right now, you will find that it has a component, even if it's just a chapter or a paragraph, speaking to how the project will impact climate change. Then another example I would provide is in relation to how they provide guidance and clarification on procedures, on institutional mandates, and how institutions are supposed to undertake their work. And I don't know if the previous council, Lynn, was able to allude to the NRT case. That was the Osman, and I actually love that case because it also speaks to what Dickens was talking about, where the community themselves, if you read that case, there are 195 petitioners, all from the community in the subwards. And they came forward and said, I mean, you guys didn't consult us. You're implementing a carbon markets project, which is going to take our community land, which we have been trying to register, yet the county government has not been giving us. You did not consult us, and it's supposed to take about 10% of our total county land. What are we doing? And so the courts interpreted it very meaningfully. And I love what Dickens and Lane were talking about, that having the community in the room is also very impactful in persuading the judge or the magistrate when they're making that decision. And what the court said was that you guys didn't do meaningful public participation. And so all this you're doing is null and void. You're in breach of our constitution, and you are subsequently, if you persist to do this, you will be in breach of the law. And another guidance they provided was they told the county government of Isiolo that you need to ensure that this community land is registered, because the community has been trying to get it registered, yet you have refused to. They're experiencing, I would say, unsubstantiated obstacles to register the community land. And then another example is how they also direct or influence country ambitions. This I have not yet seen in Africa, in Eastern Africa, or in Africa in broadly, but I have seen some examples in Europe. For example, Netherlands. Netherlands, there was Ugenta versus Netherlands. That case, if you read that case, you will find that they presented before the court that the government is not ambitious enough in their climate change ambition. And this subsequently is a breach of our human rights. Well, it's a breach of our human rights because it will leave us open to the adverse impacts of climate change. And the court agreed with them. It said that yes, as a country, you need to enhance your ambitions on climate change action. And it actually told them that you need to reduce your emissions by 25% in 1 year. So you can see how sometimes the courts can be influential and impactful in driving climate action. And so one challenge, however, that I would note from my research and from my engagement with judges and lawyers is that our capacity in submitting or filing some of these petitions, some of these applications, our motions is quite wanting. We had a meeting last year with the East African Law Society, with the Law Society of Kenya, DASTA, and UNEP, where we brought together all presidents of the bar associations, and they were seated at DASTA. And one of the speakers was Honorable Justice Anne Olo from the ELC Court of Kenya. And she said that sometimes when we receive these petitions, we look at the lawyers and wonder, how am I knowing more than you? How am I, how do I know what you should be requesting for or praying for than you? You know, like, it's more of a challenge to us lawyers. It's more of a challenge to us advocates. It's more of a challenge to the people in advocacy outside the courtroom, at the Dickens and the like. How best can we frame and package our prayers before the courts to ensure that what we submit before them gets a favorable judgment or decision on the other end. And sorry, I also forgot the story of Wangari Maathai that I was mentioning. It is one of the reasons why we currently have the locus standi cemented in Section 3 of our MCA 1999. Thank you very much for your time, and I submit waiting any follow-up or subsequent questions.
Thank you so much, Mlama Leon. That has brought it very close home, and you using cases to demonstrate the happenings. I think also it makes it easily understandable to the public who are listening to this. I just have one follow-up question before I can check if we have questions from the public. In regards to the NRT versus Osman case, that institution had 44 other conservancies, and we are talking about the implication of the ruling of the court on subsequent matters, including the law. Do you think the judgment of the court would impact the other 44 conservancies, or it's just limited to those other two? I think there were only two in this case. Would you unmute?
Yeah, oh, definitely, definitely. It actually already has. I would give not an example per se, but how currently people are now approaching carbon markets and conservancies and anything to do with our carbon sinks and carbon reservoirs or carbon sequestration sinks. Right now, public participation has been exalted beyond what is beyond ticking a box, beyond just presenting technical terms, bringing voluminous documents, taking pictures, and then saying you've done public participation. It's evolved beyond that. It's now more of engaging with the community, telling them, we want to do this. What do you think? And they give their feedback. And where possible, you amend your project to suit their needs and also your objectives as an institution. Then you go back and tell them, okay, this is what you've done. What do you think now? And it has, I personally believe that it has enhanced how organization, how project proponents, how institutions or project developers are approaching communities, especially in relation to carbon markets. There is still a gap. There is still a capacity gap, especially within our communities on carbon markets issues, but we are slowly progressing there.
All right, thank you so much. And as we close, please remember to answer this question. Do you think it's fair for the executing agencies to be the ones who are doing the public participation in regards to NEMA approvals? So you will answer that, I think, in closing, because I feel like they're already partisan, and if they're the ones who are spearheading that exercise, it seems a bit futile to me. Please answer that when we get to your closing. I will check. Gabriel, do we have Dr. Nshala? Or do we proceed to check if we have questions from the...
Let's proceed to the Q&A segment. Thank you.
All right, all right. Mtanisamea kidogo, I will be checking as I speak. All right, we have a question, I think, or a comment to to Mr. Iron Kiza. And the comment is this, I'll just read it. There was a provision in the Environmental Act laws of Uganda that provided for an environmental tribunal. In a trade policy meeting at Sheraton, where I participated, I was shocked to learn from the principal legal officer at NEMA, Uganda, stating that there is no such thing as an environmental tribunal, because my question was, when is government operationalizing the court? To my knowledge, there is no corrigendum or repeal or amendment of this provision. Mr. Kiza, would you speak to that comment as I look through the others?
Well, it is just to confirm that, yes, there is no environment tribunal in Uganda, and the judiciary has been making an forever promise of an environmental division of the High Court. The previous DCJ was big on talking about it, and the current CJ has inherited the talk. but it has not yet resulted into action. So we have to rely on ordinary courts for now in Uganda.
Understood. Thank you. Thank you so much. This is a comment maybe to East African Law Society. Thank you for the insight into climate justice litigation. I hope in future we have presentation and conversations on innovative discussions on measures to mitigate climate change. And then to Mr. Leon, many thanks for an insightful presentation. At what point is the executing agency to revert to the community to evaluate the needs they have met before project execution, or during or after considering how the changes to power dynamics during these stages? Is it clear? All right, will you speak to it?
Yes, allow me to start with your first question and whether I think it's fair for I believe you mean, when you mean executing agency, do you mean the project proponents or, okay. So yeah, I do believe it's fair. It is what is currently in our laws in Kenya, in Rwanda, in Uganda, in Tanzania, that the person who's doing the project is supposed to ensure and take the necessary measures that ensure it does not negatively impact the social, environmental, and economic, I would say, considerations of the community where it will be implemented. The challenge I have is, do we use licensed EIA experts? And how do these EIA experts conduct their assessments? So it's not even me when, for example, I'm the one who's doing a project. I won't be the one who's going to talk to the community or tell them that this is your impact. I would have to hire or get an EIA expert who will then initiate that whole process and then come and bring me the report. I may accompany him and provide clarifications or additional information to the communities, but that should be squarely on the EIA experts. Now, the challenge is if we were to swing I would say the radar to put it on the agencies. So for example, NEMA, or put it in the state agencies responsible for environment, it would, number one, introduce the new costs on their operations. So you can imagine how many projects are being run in Kenya, how many projects are being run in Rwanda, how many projects are being run in Ethiopia, how many projects in Uganda. So all this would require to have impact assessors, and then these impact assessors would then have to still report to the project proponent and the institution themselves. Where yet the current system that we have, you just commission the assessment, then the assessor submits it to NEMA for approval or recommendations, should they have any. Moving into Tayo's question, I would say at all stages, both before, during, and after. Now, before the project, that's when you do the impact assessment. But during and after, we do environmental audits. So it changes the name a bit, but it's basically the same thing. You assess, before you assess the current status, the status quo, and how the project will impact. And then during the project implementation, you're able to audit and say, okay, so this is what it's done to the community, this is what it's done to the environment, this is what it's doing in generating economic viability. And then after, were there any, you still do an audit, you say, were there any impacts to the environment? And if so, how do we remedy it? Or how do we ensure that we have addressed it and restore the community or the environment back to where it was before the project execution? I hope I have answered the questions, but I am available to provide any follow-up clarification.
Thank you. Thank you so much, Mr. Mlama. I will go to the next question, and I'm going to trust Mr. Dickens to be able to take us through this. This is a question from Anthony Munywa. He's asking, how do we ensure sustainability of climate justice, especially when it comes to climate entities like CBOs, found at the grassroots level, struggling financially to sustain the necessary programs that impact fundamentally on positive climate, especially tree planting? Where do we run for funding and or supply of the necessary items in conserving and preserving our Mother Nature?
Yeah, thank you very much. I think right now, if you ask any organization in East Africa, you'll discover that most of the organizations are struggling. In Uganda here, we had a fund for many EU countries called the Democratic Governance Facility, which was funding almost 90% of the NGOs. It was harassed and it had to cross, harassed by government. I think recently you saw how President Trump crossed he said all these were sources for organizations to get some funding. So really, there is no doubt that there is a huge challenge to organizations because most of us, we survive on funding from outside our countries. And for you to do any work, you really need some resources. So at the moment, I've been telling colleagues, even here at Afiego, that we have to become very creative. First and foremost, if you are a lawyer and maybe you have lawyers at the organization, you have to diversify. Also do some private litigation where you can generate some money. Secondly, if you are able to work with communities, in other words, have some specific communities that you are working with, build trust, build confidence with those communities, they can actually mobilize some resources when they see there is a reason, there is hope that if they take this direction, they can actually get some relief. They will support that thing. But the truth is that the struggle is there. As I said, I've been seeing like Kenya, that it is not like the decision of government to reach a point where you can even interview judges publicly. The judges are accountable to the citizens. Those things I know like Kenyans have been pushing to reach that level. Even our other countries, we have to reach a point where citizens are very cautious. Because even when we say how do you sustain some of the cases, how do you sustain a case that has been in court for over 10 years? It is almost next to impossible. In Uganda, Yafiego, we are supporting over 7,000 people who were affected by the government project where they want to build an oil refinery. Since 2014, that case is in court. We filed it in Kampala High Court, then they pushed it to the regional court in a district called Masindi. Then after Masindi, they pushed it to another district area called Hoima. And you see, every time the court hearing, you have to take these communities because they are the ones who filed the case. You have to feed them, you have to accommodate them because they don't have the capacity on their own. Today, that case, we are on the 9th judge. Judges retire, judges withdraw from the case. Sometimes it is almost next to impossible for you to have a sustainability strategy. But the beauty about it is that once the communities trust you, have confidence in you, if some will even forego some meals, some will try to sleep at their, if they have someone they know, maybe here in the city, they will sleep there, but they will stay in the case, they will continue supporting the case. So I think the trick is that the lawyers and the people who are working with organizations that are planning these strategic litigation cases, we have to be creative. And we have to continue struggling. We have to continue pushing the judicial system to be serious. Otherwise, I don't think there is any specific solution that I would be looking at. But for me, if the communities that are impacted, the communities that are going to court, if they trust you, if they believe in you, They will work with you no matter the obstacles, and you'll be able to succeed.
Thank you. Thank you so much, Mr. Dickens. To summarize what you've said, I think in Swahili we say ni kujituma. So asante sana. I have two more questions, and then I think I will close the question sessions. To Mr. Tayo, I am not quite sure who is Mr. Tayo. I think probably there's someone who is known personally by an attendee here. To Mr. Tayo, we have the Climate Change Act Cap 387A that provides for community participation. We also have the Climate Change Carbon Market Regulation 2024, where the community is involved before the implementation of the project. The community will have a community development agreement. I think that is more of a comment as opposed to a question. And then finally, I think the last question. Sorry, I speak in Swahili. Mr. Leon, good submissions. I have been following that carbon projects and the community dispute. I have been following that carbon projects and the community disputes. So there were no EPIC. And from your wisdom, would you consider carbon markets as adaptation measures to climate change or a false climate solution that keeps communities in such extra activism patterns? I do understand that most projects are dressed as developmental when they are actually not, and the carbon markets project are one of them. Mr. Leon, please speak to that, and then just one more question, and then we close.
Yeah, thank you. Allow me to also expound on Fatima's point. Yes, also if you read the schedule of our Climate Change Act, there's a procedure on how we're supposed to do our public participation. So thank you very much for that, Fatima. So moving into the question from Imam, I would term it as a mitigation action with adaptation co-benefits. Why do I say that? Carbon markets is aimed at reducing emissions, greenhouse gas emissions into our atmosphere, or withdrawing or I would say sucking, for lack of a better word, the existing GHG emissions we currently have in our atmosphere into reservoirs or storage facilities where they will not be emitted for a very long time. So a very long time is also another criteria for carbon markets. The problem with carbon markets is people believe that there is money. People believe that there is money in carbon markets. If you look at many African countries, right now they are moving towards carbon markets. And whether we like it or not, our president's already made a decision on it. They're already committed to it. And it stems from Article 6 of the Paris Agreement. So they believe that there is a lot of money in carbon markets. Now, the problem is, how do we approach it? If you look at how the EU has approached the carbon markets, they say that, okay, so we have some specific sectors which we are targeting: oil, steel, manufacture, basically the industry sector. And so they say, if you are part of this sector, you have this permissible cap. If you go beyond that cap, you have to pay a certain amount of money to the government so that it can help in the mitigation actions that it's doing nationally. So it's indirectly feeding into the NDC, into our NDC implementation. However, just as you rightly said, people don't understand it, and the people who are proposing it are not willing to come clean and share information with the communities. Like, for example, that NRT case, people who did not know that if we designate that this is the amount of land we are giving from our county, we will not be able to farm on that land, because if we dig up, we'll be emitting carbon that's stored in the soil. We won't be able to graze there because we want the forage and the plants and the shrubs that are there to continue sequestering carbon. People don't know that you'll have to cordon it off basically. No more economic activity on that land. Yeah, this is land that people rely on for their day-to-day lives. And then I don't know if you are from Kenya. There was this video that was going around where journalists went to the local communities and asked them, what do you understand by carbon markets? And people thought that it meant, ni wanauza hewa, they're selling air. So they don't know that some of this has implications on their livelihoods, on their economic activities. So just to sum it up and answer your question, it is not infutile. I think the challenge is how we approach it, how we are engaging our communities, how we are talking to the. Sorry, can you hear me?
Yes, we can hear you. We can hear you. Okay, you've stepped away. Sorry. I think he would.
I wanted just to make one point that
All right, yes,
if
please.
you look at these carbon markets, I think it is just to show the difference between poverty and rich, that the rich nations actually are using their money to push the poor nations and the poor people deeper in poverty. I have seen many communities, for example, in Uganda, where they have said, oh, you participate in these carbon markets. You find someone has 2-3 acres of land, and the family decides to turn into that one as part of the carbon market. How much money are they paid every year? And in the process, they have to go and now rent land in other people's places to grow some food, to grow everything. If you compare what they are getting as the money from carbon and what they are spending for them to survive, it is very absurd. And unfortunately, our governments are not taking the initiative to get people to appreciate the implications of these so-called carbon markets. And even as lawyers and other people who are trying to make people, to help people understand that these carbon markets are not real projects, are not intended to help people. They're intended to help the rich nations achieve their objectives, continue polluting, while we from poor countries actually get fixed into things that we don't understand. It is incumbent upon all of us, I think, people who are reading and understanding these so-called carbon markets, to make people understand. And I'm very sure if our people appreciate the implications of these so-called carbon markets, they will not be able to, they will not allow to be hoodwinked. And it is a big challenge. We need to do something about it.
Thank you so much. Thank you so much for your input on that. I agree. I think it's a continuous effort, even as we speak about the courts and the law. I think us as legal professionals, we have a duty to continuously educate the public on different aspects of the law and also the implications of some of these measures, including the carbon market. You were to finish on something, Leon, and then we can take the last questions and then we close. Okay.
Yeah, I definitely agree with Dickens, because the main challenge is our communities are entering into agreements that they do not understand. So it is our job as lawyers to step in and tell them, this is the implication. Give them the prior information so that they can consent or advise whether or not they want to do the same or not. And one thing that countries are really trying to do to at least ensure that the benefits are shared within the communities is by giving a certain percentage to the communities. For example, if I reference to what Fatma raised on the community development agreements and the Act number 9 of 2023 and the regulations subsequently, you would find that for every carbon project implementation or activity that you're doing, 40% is supposed to go to the community. That's if it's land-based. But if you're doing it on the oceans or in the air or in private property, but most of the time it will still count as land, then it would be about 25%. But just to sum it up, yes, our communities need that capacity building and information and knowledge sharing. And I love that one thing that Dickens really pointed out was our carbon pricing. Well implemented, experience a lot of challenges when it comes to. Sorry, Flavia, I think you're muted.
Sorry. Thank you so much. Tulipoteza kidogo, but we are happy you came back along the way. Asante sana. Just last question to Lynn, Mrs. Lynn Kitu, and then we can go to closing remarks. Considering the involvement of multinational actors such as Total Energies, do you think domestic courts in East Africa are adequately equipped to handle transnational climate justice claim, or is there a growing need to rely on foreign jurisdictions and international legal mechanisms? I think Ms. Lynn, you can take on this one.
I'm torn. Because yes, the truth is there's still a limitation, if I can put it like that, in regional courts, continental courts, country courts, to handle some of these cases, especially when they involve multinationals, as has been raised. However, I don't necessarily believe that the solution is to look outward. I think the solution is more to increase our capacity on the continent and in the region to handle these cases, because at the end of the day, what is it about? It's about law, policies, jurisprudence, just building that capacity to handle the cases, which perhaps can be seen on the books for international national courts. I think it's cool, because if we're saying that we want to involve communities more, to involve who are directly by different projects, environmental impact, climate change impact, then we can't at the same time say, oh, let's look for the solution out of the continent. I think the answer here is to build capacity. I was typing in the chat kind of question.
Sorry, Lynn, you're breaking. Lynn, can you hear us? You're muted now.
Sorry. Hello?
Yes, we can hear you.
Yes, so I'm done. I was done with my submission, but then I also
right.
say that I took some time to type in the chat the conversation about public participation versus community involvement.
Understood.
Just answer that question. Yeah.
Understood. Thank you so much. Thank you, the audience, for attending the session. We will get the closing remarks from the panelists, and then we can proceed to close the session. I will start with you, Dr. Kiza, and even as you close in a minute or two, I would like to close for you to answer this question. What legal developments do you believe will most shape constitutional climate litigation in East Africa over the coming years? Mr. Kiza, I'm speaking doctor to your future. Do we have him? Maybe not. All right. Mr. Dickens, coming to you. What role will community advocacy and civil society play in advancing climate justice? And I think climate accountability, and I think you've just touched on that, but just speak as to the future, what more can be done to involve the community and what more can be done to empower the society?
Yeah, thank you, Pravia. I think one thing that we've been doing here, like at Afiego, right now we have over 30 cases in the different courts in Uganda and outside Uganda. And we've been using, because all these cases are filed, we support communities to file the cases. And every community that file a case, we actually use that case to help them come into some form of, not a formal grouping, but into a structured community that can actually work together, that can even invite people to educate them. They can have work plans. So I'm hoping that if, for example, lawyers and other professionals can start writing, whether they are using social media, using radios, using print media to educate people, once people appreciate the questions of the day, I am very sure they are going to influence the judicial system. They are going to influence the decisions that are going to be made. They are going to influence the enforcement of the judgments and rulings. And most importantly, they are going to ensure that the civic space, because I know some countries, the civil society can operate without repression, but in other countries like ours, the civic space is closing, is shrinking every day. The more communities understand these issues, they are going to stand up and protect the lawyers, protect the judges, protect the magistrates. So I really believe that the community participation can push for accountability. Without accountability, even the laws that we are talking about, reforming the laws, the good laws that are around, the increase in the number of judges and magistrates may actually not help us. So we must do what we need to do to make sure that our citizens appreciate these issues and they be at the forefront of whatever reforms that we are talking about, whatever
Thank you so much, Mr. Kamugisha. We appreciate your input through this session, and we appreciate your experience that you've shared with us. What comes out clearly is that we as lawyers, we need to do more to involve the community. I think if climate justice is looked upon from a community perspective, then I think the returns are far-reaching compared to if it's just limited to legal principles. Thank you so much. I will proceed to you, Lynn. Please give us your closing remarks. I will not limit you to any direction, just open-ended. Give us your closing remarks.
Yes, so in closing, I just really want to appreciate this opportunity to discuss climate justice in action, and to say that many times, even as I said in my presentation earlier, the people who bear the burden must be supported in different ways. But there's a huge opportunity for courts to respond positively when it comes to dealing with climate justice. Also, the issue of community engagement, we can't say it enough, and going beyond the public participation provisions that are there across the laws, especially when it comes to ESIAs and things like that. That's where there's close mention of community engagement. But it's most of the time it's not even called community engagement; it's called public participation. So just being careful that public participation doesn't become a thing that can be ticked off, and then the key issues are missed out. We must remember that climate justice is equal to social justice, and intersectionality is not optional. And our legal work, wherever it's coming from, however we're doing it, it must be accessible and available to the people who are directly affected by climate change impacts. Yeah.
Thank you so much. Thank you. It's been a struggle for you because you are working, but you've taken time to be part of this session. We really appreciate you. What comes out strongly from you is the importance of involving the community and public participation, not just being a tick. So asante sana, and we hope we can continue having subsequent sessions with you as well. I'm going, yes. Thank you. Leon, I close with you, also open-ended. Take it away.
No, first of all, thank you, Flavia, for the wonderful moderation of this session. And to thank everyone, including ELS, for organizing and attending this session. My final closing remarks is a call to action to our lawyers, advocates, and legal practitioners. You are the bastions of justice. You are one of the officials or officers of the judiciary. You have legal expertise, and you bring with you an experience and expertise that is essential to the fight against climate change. So I would call upon you to contribute in any way you can, either in technical or through your legal avenues. For example, if it's drafting, if it's reviewing, if it's providing legal opinion, if it's instituting litigation, leverage on your skills, leverage on your ability to, as a lawyer, you can maneuver and inform or I would say inform the opinions of our policymakers, of our scientists, of our project implementers. And so my final call to action to take up your arms in the fight against climate change.
Thank you so much. Thank you so much. We've learned really so much from you, especially on the court cases that have impacted our laws. So thank you so much for taking time to research on that. And even from your presentation, I felt like you're really doing so much on the ground. So on behalf of Wakenya, asante sana. This is to say thank you to ELS, and also say thank you to the panelists. Each one of you has taken time to be part of this, and we appreciate that. And more importantly, to say thank you to the people who've been listening to us from the start up to now. We appreciate your audience, and we hope, again, the 2 hours have not been a waste to you. I think for me, what I'm picking importantly from here is the concept that the Constitution gives you certain rights in regards to having a clean environment, and you can have a claim because of such rights. But additionally, the concept of public trust stood out for me, because whatever is happening from where I'm coming from in a region like Kenya, what the government is doing with the resources that they're entrusted with and how they are reacting to the climate impact, I think us understanding that we can have a claim under public trust doctrine is very, very important, and we should pursue that. But also what has come to the forefront to me is the importance of public participation involving the community in litigation, and not just litigation before litigation, being part of the public participation. And I think it will start from the bills, it will start from any government action, it will start from any executing agency action, and then now it will proceed up to litigation. And of course, always being advocates who are empowering the community so that they can know the happenings in the government, and so that they can understand the impacts of the happenings of project or government activities on them. So again, nikujituma, and let's continue doing the good work. Back to you, Gabriel.
Wow, amazing. Thank you so much, Flavia, for that very Wonderful session. It was really captivating and kept us alert all through. To our audience on YouTube and our audience that managed to join us via Zoom, thank you so much for your constant support. To your esteemed panelists, Lynn, Dickens, Leon, Aaron, Dr. Nshala, thank you so much for making time to being a part of this session. We look forward to having more and more and more of you. And hopefully, as we gear up for Zanzibar for our annual general meeting, we hope to continue this discussion, Leon, through a panel discussion that can generate something. Otherwise, from us to you, we wish you a very lovely afternoon. Enjoy the rest of your day. Until we meet again next week, goodbye. We will share a recording of this session on your emails along with any materials that our speakers will share. Otherwise, from us to you, have a very lovely weekend, and we meet again on Tuesday. Goodbye.
Bye. Thank you.
Bye-bye.